former president in the state of Ohio versus Louis Marconi, case 22 CR 1322. Defendant is in court represented by counsel. We are here today for purposes of a change of plea. It is my understanding that the defendant is going to withdraw his previously entered plea of not guilty and plead guilty to count 1 in the indictment, failure to appear, a felony of the 4th degree. In regards to sentencing, there is no agreement, but I believe both parties are prepared to proceed to sentencing today.
Thank you. Watson, does that sound accurate?
Thank you, Your Honor. Please the court, that is my understanding of this afternoon's hearing. I've had a chance to fully pre-try this matter with the state. I've also had an opportunity to discuss this matter with my client. He is prepared this afternoon to enter a change of plea. He understands that by doing so, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so, Your Honor. Also, with regards to sentencing, since he's already serving a sentence on a prior case, he will waive a PSR and will agree to proceed straight to sentencing.
Thank you. Mr. Marconi, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe you want to do this afternoon?
Yes, sir.
Indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and our plea of guilty to the charge in the indictment. We would then proceed straight to sentencing, where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe would be the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here at this time?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand what we're doing here. I need to make sure you understand the rights you have that you give up by pleading guilty, the possible penalties you face. You need to make sure you understand what it is you're pleading guilty to. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you would like a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Judge.
All right. Let's get started then. How old are you, sir? How old are you?
41.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No, sir.
What about within the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
No.
Did you receive, I know you did, you got a copy of this indictment about a month and a half ago or so. It's the document, or a month ago, that's the document that sets forth a specific charge you're accused of and what you're admitting to. You get that?
Yes, sir.
Had a chance to look that over?
Yes, sir.
In that indictment, you are charged with one count. What's alleged here and what you'll be admitting to is on or about November 28, 2022 in Lake County, Ohio, that you did fail to appear as required in case 22 CR 607 after having been released on an open cognizance bond pursuant to Section 2937.29 of the revised code. It's further alleged that your release on their own recognizance bond was in connection with a felony charge, which makes this offense failure to appear as a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, Judge.
Any questions about it?
No, sir.
Well, then, before I can accept your plea, I need to make sure you understand all the rights you are giving up. And you first of all have a right to a trial. Trial could be to me as a judge where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial, which would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And the ultimate decision reached by those 12 jurors would have to be unanimous, which means all 12 of the jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. Having the burden of proof means it's her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of this charge, and that presumption of innocence would stick with you and remain with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden we have in our justice system. What it means is it's the amount of the evidence and the quality of the evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge beyond any reasonable doubt before you could ever be found guilty at a trial of this charge. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, prosecutor is going to bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Now, once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He can ask him anything he wanted to, within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Judge.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court and testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request this court issue an order, and we call that order a subpoena. What a subpoena would actually do, it would force or make someone come to court, testify for you, and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, prosecutors are not allowed to call you as a witness and make you get up on the stand and answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, Judge.
Now, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Do you still want to plead guilty?
Yes, Judge.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it, or it's someone else's fault, or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you are pleading guilty to a felony of the fourth degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
I know you're currently serving a sentence right now. Are you on probation or parole or anything like that right now?
No, Judge.
Okay. You're currently serving a prison term that was imposed by this court recently. I need to advise you that at the time of sentencing in this case, if I were to impose a prison sentence, I could run that prison term either concurrent or consecutive to the term that you're already serving. Concurrent means you'd serve it at the same time together. Consecutive means one after the other. You finish the prison term on the first case. Once that's complete, then you'd serve the prison term on this case. You understand the difference there?
Yes, Judge.
So in this case, the maximum prison term that you impose is 18 months, and it could be consecutive to what was previously imposed. You understand that?
Yes, sir.
If a prison sentence is imposed, in this case, upon your release from prison, you could be placed in what we call post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it could be up to 2 years. Do you understand that?
Yes, sir.
And if you are on post-release control and ever violated any of the conditions of your supervision, the parole authority can send you back to prison or return you to prison as punishment for violating their rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Judge.
Now, in addition to the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined up to $5,000. You could be ordered to pay court costs. You could also reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence. I did use the word possible. Prison is not mandatory in this. For this case, you are technically eligible for probation, or what is called community control sanctions. Now, to be eligible to actually get community control sanctions, a pre-sentence investigation has to be completed regarding this case. What's been advised here is that due to the fact that you're currently serving a prison sentence, you're going to waive a pre-sentence report. Is that correct?
Yes, sir.
So you understand that I will not be able to impose probation in this case?
Yes, sir.
Lastly, when we do proceed to sentencing, you'll have the right at that time to say anything you want. Your lawyer can speak on your behalf and recommend the sentence to court. The prosecutor could also recommend the sentence to court. Do you understand that?
Yes, sir.
Do you understand that whatever the lawyer said at sentencing regarding what they think the sentence should be, it is just what I said, it's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. You understand that?
I understand, Judge.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time in this case to talk about it with your lawyer and have him answer your questions for you if you had any?
Yes, sir.
Satisfied with his advice and counsel?
Yes, sir.
Has he or anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes.
All right, then any questions from me at this time regarding anything we've talked about, the rights you're giving up, penalties you face, what you're pleading guilty to? Any questions?
No, Judge.
You need any more time to speak with your lawyer before we go forward with the actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her and what she says, because then I'll have some questions for you, all right?
Yes, sir.
Ms. Leshy?
Thank you, Your Honor. The evidence would show that on or about November 28th, 2022, in Lake County, state of Ohio, the defendant failed to appear at sentencing as required in case number 22 CR 607 after having been released on an own recognizance bond, and that the defendant's release in that connection with that case was in connection with a felony charge. Thank you.
It was 607, you said? believes the evidence would show if we did have a trial?
Yes.
What, if anything, do you have to say about that in regards to the facts that she presented them? Are they true? Did you do as she said?
Yes, sir.
Very well, then, regarding count one here, charging with failure to appear, felony of the fourth degree, what is your plea to that?
Guilty, sir.
All right, I have in my possession at this time a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document and that you signed it here in open court. Now, my understanding is before I came out here, you had a chance to go over this with your lawyer. Is that correct?
Yes, sir.
Mr. Watson, is that accurate? Did you review this with Mr. Marconi, read it over with him, answer his questions?
Yes, Your Honor, I reviewed the written plea of guilty form with my client, went over with him. He indicated that he understood it, he signed it in my presence, and I signed it in the presence of the prosecutor, Your Honor.
Is that correct, Mr. Marconi?
Yes, sir.
You understand what this document says?
Yes.
And did you in fact sign it, as your lawyer said?
Yes, sir.
And Ms. Leshy, you witnessed that as well?
Yes, Your Honor.
And I also appreciate you eliminating the extraneous stuff here. But did you do that, or someone else did that?
Wait, I'm sorry, I missed.
Can you change your plea form? There's all the stuff that doesn't apply.
I took that out.
Yeah, I appreciate that.
Yes, thank you.
Talk to your fellow colleagues about that as well.
I will.
All right, this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea by the defendant guilty of count one, failure to appear, felony of the fourth degree in violation of 2937.99 of the revised code. At this point, Mr. Watson, is there any reason not to proceed the sentencing?
No, Your Honor.
Is there anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. I know we were just here on another case for sentencing. My client was given a 10-month sentence on that case. Your Honor, the long and short of it, he knows what he did was wrong. He's here today to take responsibility.